Well, I think it does indicate that they maybe are sensing the legal flimsiness of both their case and, of course, this really, frankly, this outrageous request for emergency relief.
Take a bite out of
liberty, freedom.
This is Mike Stenhouse. Welcome to another edition of Liberty Bites, where we expose how the extreme left and their allies are perpetually trying to take a bite out of your liberties. Today, our guest is going to be Jon Riches, Chief Legal Counsel for the Goldwater Institute, who is representing Nicole Solas, the South Kingstown mom, who was actually sued by the teachers union allies of the town of South Kingstown School Committee for asking too many questions about what the curriculum would have been for her daughter who was attending South Kingstown Public Schools. The left is perpetually going after our liberties, but the center right has a strong legal system out there to fight back. So joining me now is the attorney for Nicole Solas, the South Kingstown mom. Jonathan, you guys were via Zoom in Rhode Island Superior Court today, and I think your team and Nicole Solas won a big initial victory. Tell us about that.
Sure. Thanks, Mike. Yeah. So you do know, of course, the union sued Nicole when she requested information about what her daughter would learn in kindergarten, but they not only sued her, they also requested emergency relief, essentially an order from the court telling the school district to stop the APRA process, the public records process, entirely with respect to Nicole's requests. So the hearing this morning was on the union's motion to do that, which of course we vigorously opposed. And as the hearing started, rather than pursue this baseless motion, which has no base in the law, the union decided to withdraw its motion, which means that the APRA process is going to continue for these requests, for other requests, and now we're going to set a hearing on whether to get the whole lawsuit dismissed.
So in layman's terms, they were looking for a temporary restraining order. You were on this show. Nicole was on In the Dugout just a few weeks ago, as was Judge Flanders. You pointed out what a frivolous, not only the whole lawsuit, but this temporary restraining order was. Apparently that scared them off a little bit. So they would it be safe to say, rather than embarrass themselves further in court, they just dropped the temporary restraining order idea?
Well, I think it does indicate that they maybe are sensing the legal flimsiness of both their case and, of course, this really, frankly, this outrageous request for emergency relief.
All right. Now, a temporary restraining order is usually only granted when a judge feels like the plaintiff, in this case, the union, has a probable chance of winning. So everybody in this case pretty much understood that the entire lawsuit probably isn't going to succeed, but the entire lawsuit is still on, and you guys have filed a motion to dismiss it outright. Is that correct?
That's right. Yeah. So for the temporary restraining order, the first question is, what's the likelihood of success? So, we have contended all along that the union has no legal standing to bring a reverse FOIA case. The case law is abundantly clear on that. So we think that they would have zero likelihood of success on the temporary restraining order, which is what we argued. So they withdrew that. And now we have also filed a motion to get the entire lawsuit dismissed on that grounds. The union is without a legal basis, and also under Rhode Island's anti-SLAPP statute.
We're going to get into that in just a second. We're talking with Jon Riches from the Goldwater Institute in Arizona, who's representing Nicole Solas from South Kingstown. They won a big initial victory today in Rhode Island Superior Court in defending not just Nicole, right, Jonathan, but all parents and the public's right to have the liberty, to have the access to public information. And we know the unions and their government friends want to take a bite out of that liberty. I mean, it's not just in Rhode Island this is happening, right?
This is happening throughout the country, unfortunately. And the NEA, the parent organization for this plaintiff in this lawsuit, has gone on the record to say they're going to oppose parents who have questions about some of these highly politically charged curriculum. And so, yeah, I mean, look, we've always viewed this as a pure harassment, a pure intimidation tactic by the union. And by getting an early legal victory and by ultimately getting this frivolous case dismissed, I think it's going to send a message right back to the union that they're not going to be pushing parents around who just want to know what their kids are going to learn.
And there's a bigger message. Last question you're trying to send to the union: don't do this again, or you could end up paying damages and attorney's fees on our side. Because explain the SLAPP provision in Rhode Island law or federal law, and because they're not doing this honestly. They're just trying to interfere in the APRA process, purposely throwing cogs in the wrenches here. You guys aren't just pushing for dismissal and a court victory. You're actually pushing for damages. All yours, Jonathan.
Right. So Rhode Island has what's called an anti-SLAPP statute. SLAPP stands for Strategic Lawsuit Against Public Participation. A lot of states have these laws on the books, the majority of states. And Rhode Island's is particularly robust. It's particularly strong. What it says basically is if a lawsuit is brought that interferes with, or for the purpose of interfering with, a party's exercise of their rights, generally their right to free speech or their right to petition, which is very, very broadly defined under the statute, then the defendant, in this case, Nicole and her husband, can move for expedited dismissal of the case and can also seek attorney fees. And if you can show that the case is frivolous or was brought to interfere with Nicole and her husband's exercise of their right to public information here, then you can also get an award of compensatory and punitive damages.
And you guys have to file a motion to actively seek that, or would the judge just automatically do that or not?
We've done two things. We filed a motion that this violates Nicole's rights, so it violates the anti-SLAPP statute. And then with that motion, we filed a separate motion to get discovery on this question of why the union just named Nicole and her husband and no other parties, why they brought this lawsuit, to get more information on that. And if the evidence reveals, and I think frankly the case itself already shows this, but if additional evidence reveals that this was brought for purposes of harassment or to interfere with Nicole's exercise of her right to receive public information, then we're gonna seek damages.
So not only are you trying to send the message that such frivolous lawsuits may lose in court, but if you are shown to purposely try to halt a legitimate legal procedure, that there could be fees and damages that unions might be assessed by the courts as well. It's Jonathan Riches. Good luck in step 2. We'll have you back after the next procedures occur here in Rhode Island. Thanks for joining us on Liberty Bites.
Thanks, Mike. Appreciate it.